नमस्कार, राज्यसभा टीवी के खास कार्यक्रम संसदीय वाद विवाद में आपका स्वागत है। मैं हूं अरविंद कुमार सिंह। इस एपिसोड में हम आपको दिखाने जा रहे हैं गैर सरकारी सदस्यों के विधेयक के तहत हुई राज्यसभा में एक बेहतरीन चर्चा। सांसद के दुआ ने गैर सरकारी सदस्यों के विधेयक के तहत संविधान संशोधन विधेयक 2012 पर चर्चा के लिए प्रस्ताव किया। इस विधेयक में सुप्रीम कोर्ट के मुख्य न्यायाधीश और न्यायाधीशों के वकालत करने से संबंधित पहलुओं पर विचार करने का प्रस्ताव किया गया। ये बहुत ही बेहतरीन चर्चा रही, जिसमें इसके बहाने पूरी की पूरी न्यायपालिका से जुड़े तमाम पक्षों पर काफ़ी गंभीर विचार विमर्श हुआ। आइए आपको दिखाते हैं वाद विवाद।
माननीय सभासदों, माननीय सभापति जी।
Okay. Constitutional Amendment Bill 2012, Amendment of Article 124. Sri H.K. Dua.
Thank you, Mr. Deputy Chairman. I introduced this bill nearly 2 years ago in the House. It deals with a matter of high importance of public policy.
Ask him to
It
speak.
has also been bearing on it has bearing on the credibility and independence of the highest court of the land.
Certainly this bill has been moved, sir. But while debating on judiciary, sir, the degree of restraint needed shall be maintained, sir. That's the only request I'm making about Mr.
That is well taken.
Certainly, I personally I would accept.
Self-restraint is needed here.
Certainly, no names will be given and the restraint will be exercised. So this bill is focused only on the working of the judiciary. And it is sad that judiciary should become the subject of controversies or conversation among the people at different levels. The reason being, the functioning of the lower courts is really bad and people are feeling disillusioned with the working. The high courts also, during the last few years, have come in to comment, adverse comment. Arrears are piling up by the day. Justice is delayed. Quality of justice is suffering. And the redress is not available. The last hope of the people is the Kachari, is the Supreme Court of India. This bill focuses on one aspect of the Supreme Court's function, not on the wider reforms which people have talked about about Supreme Court's functioning, appointments, accountability, functioning of the collegium. I'm not going into that. This bill is to amend Article 124, only Clause 7, which forbids the retired judges of the Supreme Court, including the Chief Justices, for doing chamber practice, giving opinions in private after the retirement, again I would emphasize, indulging in liberally in arbitration, in where major companies, corporates of the corporate sector are involved. Should they take up or not those kind of assignments? Clause 7 of Article 124 forbids it. But that clause is being violated or ignored, to put a better word, by the retired judges of Supreme Court, including Chief Justices. They are liberally doling out opinions in their chamber. They are liberally taking up arbitration cases and offer arbitration. Hearings are held in Geneva or London or New York or Tokyo or wherever is convenient for everywhere at a high fee. Personally, I think the Supreme Court judges should not take up this assignment. Clause 7 forbids it. And they are ignoring the spirit and the letter of Clause 7 of Article 124. Why they are attracted to it? Once upon a time, they were very eminent lawyers, then they become High Court judges, and they come to Supreme Court. That's the apex court and the highest honor judiciary country can give to a judge is to be member of the Supreme Court. Should that kind of dignified status in the country's constitutional scheme of things should go down in public esteem by doing practice for the sake of earning money, which apparently they don't get that kind of money in while on the bench. By doling out opinion, arbitration cases where both the companies have to give the fee, incomes go up and they earn much more than they would have got through the salary or retirement benefits. Now, not only the spirit of the Article 124 Clause 7 is being ignored or violated, what is forbidden is being amply being practiced. Who suffers? It is the prestige of the Supreme Court that suffers. The last hope of the people to seek justice in the Supreme Court. If the prestige and the credibility of the Supreme Court suffers, the country suffers. And that loss of credibility leads to loss of respect of the people, and if people lose respect of the highest court of the land, then its independence can also suffer in a way. So I would like this clause to be amended and made tighter, so that in future judges and Chief Justice of the Supreme Court do not take post-retirement engagement with dispensation of chamber justice.
Duaji, what is the harm in using their experience and expertise by their own? What is wrong in that?
I will give a remedy for it.
Yes.
Article 1247, Mr. Deputy Chairman, of the Constitution as now reads, quote, "No person who has held office as a judge of the Supreme Court shall plead or act in any court or before any authority within the territory of India." This prohibition is very clear. There is no ambiguity about it. It's well-settled principle of law that anything which is forbidden to be done directly cannot also be done indirectly. But judges of the Supreme Court and some of the former Chief Justices are doing what is forbidden. I would like this clause to be amended, and the amended clause would read, quote, "No person who has held office as a judge of the Supreme Court shall plead or act or express written opinion or engage in arbitration in any court or before any authority within the territory of India and outside India." Addition is outside India also. Provided that he may do so upon a request made by the President or the Prime Minister of India or the Governor or the Chief Minister of a state in a matter of national importance. Supposing some inquiry commission has to be appointed, or a retired Supreme Court judge is needed for appointment as chairman of the Human Rights Commission. Now that's a matter of state and highest public importance. So those kind of assignments are valid. The amendment of the clause, I will recommend to the House, this August House, should remove the grey area, so the judges should not take this. Certainly they lose income, but they should be compensated. And I would suggest if the Law Minister could come forward with a bill to enhance the retirement age. At the moment, the Supreme Court judges retire at the age of 65. It can be made up to 75. And hard work they are doing in dispensing justice after retirement should be given to the country, to the Supreme Court itself, so that there should not be any temptation or their families should not suffer because of the loss of income. So I have a respect for Supreme Court, and if I have moved this amendment, it is because I would like Supreme Court to retain the kind of prestige it has, and it should not go down in the people's eye. I hope this House will support the amendment.
Shri Shantaram Naik.
Sir, I stand here to support the Constitutional Amendment Bill 2012. See, aspect of arbitration is not new in India. Let me first highlight what was the background of passing the arbitration laws in this country. The Arbitration and Conciliation Act 1966, which is the present law, replaced 3 legislations. Now this alternate redressal mechanism, which has become very popular in this country and elsewhere also perhaps, plays an important role in judicial dispensation. As I said, we had also old practice of resolving issues outside the forums of court. Our old panchayats, they have resolved a number of lakhs and crores of disputes of villagers. In families also, many matters are resolved before they are brought before a court. This is a part of alternate redressal mechanism. And incidentally, I was the chairman of Law and Justice Committee, which I have dealt with these matters. Therefore, I have said background of what was the mechanism prevailing then. Secondly, what I am saying is, although judiciary is independent, government should have some mechanism to evaluate judgments of the courts of law, not to interfere, but judgments passed by various judges in various courts, which will help them also in day-to-day functioning of the law ministry also. But presently I don't think any such mechanism is there. Especially I would request the Honorable Law Minister to study the judgments passed as regards corporate bodies, so that at the time of retirement also you know what type of judgments are given with respect to corporate bodies. Apart from this straightaway alternate redressal mechanism, there is a bill or legislation, good legislation, Consumer Protection Act, under which also alternate redressal mechanism is there. There are district forum, state forum, etc. But some people have found it not suitable. I don't know why. They say lawyers go there, they argue, lots of petitions are pending. Therefore, they are comparing arbitration and these forums to make a point, whatever it may be. When bill is pending, judicial standards and accountability bill, by which we try to lay down certain conduct of judges. Why this occasion arose is that apart from certain provisions of the Constitution, we have as a parliament or as a government, rightly so, no control over the functioning of the judiciary. But there was a view that some conduct of theirs should be regulated, and therefore a bill has been introduced. But unfortunately, there was a strong opposition from the judiciary itself that such a bill should not be there. In the course of that committee which I was presiding over, a subject also came, that off-the-cuff remark passed by the judges saying that, was Parliament sleeping? What were they doing? These sort of remarks, whether should be allowed to be passed by the judges, is also a subject which is coming under this standard bills. Now, another reason why arbitration should be taken over or not be taken over by the judges is this. These type of arbitration, despite the facilities provided by the government and the law ministry, this arbitration takes place in 5-star hotels, and as it has been rightly pointed out, most of these arbitration also take place in foreign countries, and that is why there is an attraction for the Supreme Court judges to involve themselves in arbitration. Secondly, there is a charge that judges provide for themselves a post upon retirement. There are various corporations, commissions. Apart from this, if they are also allowed to be arbitrator and chamber practice, both have been included, then there will be no end to this. And therefore, there must be some limit laid down. Secondly, judges also do not inspire. If you see the overall judgments, they don't inspire that he is fair. They encourage upon day and day out in the parliamentary realm. We have seen it. We have discussed it several times. Whatever legislation are to be passed by Parliament of India, they pass in the name of guidelines. The powers which our ministries and departments, you will experience now, the powers that you will be exercising will be exercised by Empowerment Committee of the Supreme Court from time to time. Where is the Environment Ministry today? Environment Ministry hardly has got any power. The Empowerment Committee will decide what should be done with respect to environment. Special investigation team, all criminal law will be handled by them in most of the cases now, in powerful cases. Therefore, if these are to be allowed, and this is what the inspiration is from Supreme Court, then I think the bill of Duaji should be there and should be respected and should be allowed to be passed.
Thank you very much.
इस चर्चा में शामिल सांसदों का मानना था कि उच्चतम न्यायपालिका की गरिमा की बहाली के लिए सरकार को हर संभव कोशिशें की जानी चाहिए और ज़रूरी कानूनी उपबंध भी। फिलहाल लेते हैं एक छोटा सा ब्रेक और उसके बाद आपको दिखाएंगे ये वाद विवाद।
कई जजेस एडिशनल सेशन जज रिटायर होते हैं तो प्रैक्टिस शुरू करते हैं, लेकिन अपने ऊपर उन्होंने सेल्फ रिस्ट्रेंट रखा हुआ था है भी कोई जज जो उनके नीचे काम करके आया है कभी भी उनके सामने पेश नहीं होते थे, उनकी कोर्ट का कभी केस नहीं लेते थे। ये एथिकल अमेंडमेंट है।
ब्रेक के बाद आपका स्वागत है। आप देख रहे हैं हमारा खास कार्यक्रम संसदीय वाद विवाद और मैं हूं अरविंद कुमार सिंह। हम चर्चा कर रहे हैं संविधान संशोधन विधेयक 2012 पर। सांसदों का मानना था कि अनुच्छेद 124 में संशोधन के माध्यम से सुप्रीम कोर्ट के जज और मुख्य न्यायाधीश इनको वकालत से वंचित करने के बजाय कुछ और प्रावधान करके उनको राहत देने की ज़रूरत है ताकि उनको वकालत करने की ज़रूरत ही न पड़े। आइए आपको दिखाते हैं आगे का वाद विवाद।
P. Rajeeve,
Deputy Chairman, I rise to support this bill. This constitutional clause 124(7), no person who has held office as a judge of the Supreme Court shall plead or act in any court or before any authority within the territory of India. This is a pre-globalization clause. At the time of framing this clause, the activities of companies confined within territories, national territories. Then this clause is suitable for that day. Now we are living in a globalized world. A company can run an office in the United States of America and they can run their activities in India. Indian companies, they are running several business outside the country, America, Britain, several other countries. Then now the global capital flows from one country to another country wherever they get more profit. Now the global capital has no specific national interest. Then this clause should be amended. Not only this, nowadays the court itself has created their own after retirement vacancies. While here in the case of education institution, the apex court had a verdict. In that verdict, it is the duty of the executive to constitute a committee under the leadership of a retired judge, that is ensuring an after retirement vacancies. Recently, hearing the accidents and traffic rules, apex court made another verdict. In that verdict, the court itself created a committee to review the rules, the laws. That is a responsibility of the legislature. It should be noted and that should be included in a comprehensive amendment, constitutional amendment, to avoid that type of activities. Third point, sir, this is this arbitration case. The former Attorney General wrote to the publicly mentioned that CJI, not only the judges of the apex court, former Chief Justice of the country, appearing for a private company in United States of America, then what they would think about the independence and credibility of the judicial system in our country. We are living in a globalization process. this clause should be amended. One more point, sir. In this statement of objects and reason, Dubaji correctly stated that the proposed amendment to this Article 124 of the Constitution required to ensure the strength, the judicial independence and maintain the credibility of the higher judiciary. Recently, Chief Justice of our country made a public remark, very important issue, that is the attack on the independence of our judiciary. We have a collegium system. All of us well aware that there is no word collegium in the Constitution. The collegium sent a proposal to the government. The government suffragate that one name and approved to other three names. I think first time in the history, the Chief Justice of India made a public remark against this government. This is an attack on the independence of judiciary. I think that type of thing should not be happen. We have our own Lakshmana Degas. I am fully support that argument. This existing system of judicial appointment should be amended. But this is the rule of the day. We are creating that loopholes for the judiciary to constitute a collegium because we failed to do our duty. But before amending the existing legislative mechanism, this is the duty of the executive to ensure the independence of the judiciary. I think the government should review the approach they had taken in that issue. And I also request the government to come with a judicial reform commission, judicial appointment authority, taking the views of all stakeholders. These words I conclude. I support this constitutional amendment bills. Thank you.
Avinash.
धन्यवाद सर। मैंने भी 10-12 साल एज ए लॉयर प्रैक्टिस की है, तो जजेस के बारे में जो एक ओपिनियन होता है लॉयर्स का और आम लोगों का, वो नेक्स्ट टू गॉड, वो उसको एक परमात्मा के रूप में देखता है। बहुत से एडवोकेट्स जो करोड़ों की प्रैक्टिस होती है उसको छोड़कर वो जज इसलिए अपॉइंट हो जाते हैं कि एक रिस्पेक्टफुल स्थान पर वो जा रहे हैं। मैं एक पर्सनल एक्सपीरियंस आपसे शेयर करना चाहूँगा कि मैं जब लोअर कोर्ट में प्रैक्टिस कर रहा था तो वहाँ 2 कोर्ट्स बनी। जो दूसरी कोर्ट बनी, वहाँ के एक रहने वाले जज, वो हाई कोर्ट के जज हुआ करते थे, वो रिटायर हो गए। रिटायर होने के बाद सब ने कहा कि आप एक नया आपके गांव में, शहर में कोर्ट आ रही है, आप आइए, उद्घाटन है तो आप इसमें पार्टिसिपेट कीजिए। तो बड़ी आग्रह करने के बाद वो आए। उनको कहा कि आप बोलिए। उन्होंने बोलते हुए एक शब्द कहा कि जितना समय मैं जज रहा, मैंने कभी भी अपने को इंस्पेक्टिंग जज के लिए कभी ऑप्ट नहीं किया। जब भी मुझे कोई इंस्पेक्टिंग जज बनाता था तो मैं उसको रिफ्यूज़ कर देता था। कारण कि जो मैं ये देख रहा हूँ कि जिस ढंग से स्वागत हो रहे हैं, पार्टियाँ हो रही हैं, ये कहाँ से और कैसे मैनेज होती हैं, इसका मुझे डर लगता है। उन्होंने पब्लिकली कहा। तो जुडिशली जो है वो एक ऐसा एक आदमी के लिए, जब सब रास्ते बंद हो जाएं एडमिनिस्ट्रेशन के, पॉलिटिकल, तो एक जुडिशली ऐसे रास्ता होता है जहां जाकर किसी इंसान को कोई रिलीफ मिलता है। अभी शांता जी बात कर रहे थे कि जजेस आउटसाइड दी कोर्ट जब कॉम्प्रोमाइज़ करवाते हैं तो उसका कितना इम्पैक्ट रहता है। मैं एमएलए था तो उस समय मैं प्रैक्टिस भी करता था, तो एक 800 रुपये की लक्कड़ का केस, उसमें 16 केस बन गए, सिविल और क्रिमिनल। तो जज बहुत अच्छे थे। उन्होंने मुझे कहा कि देखो आप एमएलए हो, आपकी कंस्टिट्यूंसी का केस है और आप एक तरफ वकील हो, इसको क्यों नहीं ख़त्म करवाते। मैंने कहा जी ये ख़त्म नहीं होगा, आप ख़त्म करवा सकते हो। कैसे? आप हमें बाहर निकालिए और दोनों पार्टीज़ को एक जरा स्ट्रांगली कह दो कि मैं दोनों को अंदर दे दूंगा, तो नहीं तो आप कॉम्प्रोमाइज़ कर लीजिए। तो हम आर्गू करने गए तो कहा कि आप वकील साहब बाहर जाइए, मैंने क्लाइंट से बात करनी है। तो आधे घंटे बाद दोबारा आवाज़ पड़ी तो उन्होंने डेट दे दी। तो 5 मिनट बाद दूसरा क्लाइंट मेरे पास आ गया कि साहब मेरा राजीनामा करवा दो। तो एक राजीनामे ने, एक कॉम्प्रोमाइज़ ने जज की इंटरवेंशन से 16 केस खत्म करवा दिए। सो ये एक जज का एक अपना इंपॉर्टेंस रहती है। लोग जज की बात को, जज को एक देवता के समान जो है वो समझते हैं। जजेस एडिशनल सेशन जज रिटायर होते हैं तो प्रैक्टिस शुरू करते हैं, लेकिन अपने ऊपर उन्होंने सेल्फ रिस्ट्रेंट रखा हुआ था है भी कोई जज जो उनके नीचे काम करके आया है कभी भी किसी भी सर्विस के दौरान, तो कभी भी उनके सामने पेश नहीं होते थे, उनकी कोर्ट का कभी केस नहीं लेते थे। वो सेल्फ रिस्ट्रिक्शन वो है। ये जो अमेंडमेंट है मैं समझता हूँ कि एथिकल अमेंडमेंट है। तो एक बहुत ही इंपॉर्टेंट बात इस आर्टिकल 1247 सबसेक्शन 7 में लिखी, तो लेकिन समय में परिवर्तन आया, बहुत से कमीशन बने, बहुत से एक्ट बने, उसमें जुडिशियल और लीगल जो लोग थे उनकी इन्वॉल्वमेंट आगे बढ़ने लगी। तो इसलिए आफ्टर रिटायरमेंट फिर असाइनमेंट्स लेने का वो समय आ गया। असाइनमेंट लेने के साथ साथ पर्क्स और अलाउंसेस वो भी इतने ज़्यादा हो गए। कई बार आपने को जज अपॉइंट किया है, आपने को रिटन ओपिनियन दिया, तो उस जज के सामने वो ओपिनियन चला गया तो फाइल में उसका माइंड वॉइस हो सकता है। हो ना हो बात की बात है, वो उसको माने ना माने बात की बात है, लेकिन उसका जो माइंड है ओपिनियन देते समय, इंटरप्रेशन करते समय हो सकता है कि वॉइस हो। दुआ जी ने बहुत इंटेलिजेंटली एक प्रोवाइजो भी दिया है, अगर ऐसे किसी जज की देश को जरूरत है जिसका ओपिनियन प्रेसिडेंट या प्राइम मिनिस्टर, चीफ मिनिस्टर या गवर्नर वो चाहता है कि उसका ओपिनियन जो है वो आए, वो हमारे स्टेट को या देश को रिप्रेजेंट करे, वो जाए, तो उस कंडीशन में उसकी सेवाएं ली जा सकती हैं। तो इसलिए कोई ना कोई ऐसा रास्ता निकले जिससे इस बिल में जो कहा गया उसकी भावना की रिस्पेक्ट भी हो और हमारे जजेस का मान सम्मान पब्लिक में भी और सारे देश में भी बढ़े और जुडिशरी में और विश्वास बढ़े, ऐसा भी हमें बहुत ज़्यादा करने की जरूरत है। बहुत बहुत धन्यवाद।
कुल मिलाकर उच्च न्यायपालिका की गरिमा को लेकर हुई यह चर्चा काफ़ी सारगर्भित रही। सांसदों ने दलगत राजनीति से परे हटकर इस विधेयक का समर्थन किया और माना कि उच्चतम न्यायालय के मुख्य न्यायाधीश और न्यायाधीशों को कार्यकाल खत्म होने के बाद ना तो वकालत करना चाहिए और ना ही सलाह देना चाहिए। वहीं दूसरी ओर सरकार को भी उनकी भरपाई करने का इंतजाम करना चाहिए। इस एपिसोड में फ़िलहाल यहीं तक। आगे के एपिसोड में हम आपको दिखाएंगे कि सांसदों ने चर्चा में और क्या कुछ कहा और मंत्री ने क्या जवाब दिया।
The judicial system should be independent. They should not do something which will create a color in their life to say that they have taken a decision in that particular judgment because they sought for a governorship, they sought for a Rajya Sabha membership, they sought for a particular position in Human Rights Commission or in the tribunal or any such position. They should be the autonomous body as the constitution makers make it.